Greetings from Brady Martz. My name is Harmony Coling. Today, I'm going to go through what employers need to know when navigating the Coronavirus Aid, Relief, and Economic Security Act that was passed in the Senate on March 25th and the House on March 27th. The topic that we're going to cover today includes the Paycheck Protection Program loans, the loan forgiveness of the Paycheck Protection Program loans, the employee retention credit, the delayed payment of employer payroll tax and self-employment tax, and an overview of unemployment insurance provisions. First, let's cover the Paycheck Protection Program loans. This program was established to let small businesses, nonprofits, and individuals seek out loans for COVID-19 specific release using the SBA's 7A loan program, and is intact from February 15th, 2020 through June 30th of 2020. However, businesses must have been operational as of February 15th, 2020 in order to qualify. Businesses must have also paid out salaries and payroll taxes and must have no more than 500 employees. This does include sole proprietors, tribal entities, and nonprofits. These loans can assist with covering the following expenses for these businesses: payroll expenses, interest on mortgages, rent, utilities, and interest on other debt obligations that were already in place prior to February 15th of 2020. These loans can have a deferment of repayment for a period of at least 6 months, but not to exceed a year, and also have a maximum maturity of 10 years. The interest rate cannot exceed 4%, and lenders will not require application fees, closing costs, or collateral to be paid. Also, the loans are federally guaranteed, so there's no personal guarantee required by the business owner in order to qualify. The calculation of the amount that the business is qualified to obtain is going to be the lesser of the sum of the average payroll costs for the 1-year period ending on the date the loan was made, multiplied by a factor of 2.5, and any disaster loan amounts taken out after January 31st that have been refinanced into a paycheck protection loan, or $10 million. Payroll costs are defined in this program as the sum of the following: wages, commissions, salary, or other similar compensation to an employee or independent contractor, payment of a cash tip or equivalent, payment for vacation, parental, family, medical, or sick leave, an allowance for a dismissal or separation of an employee, payment for group healthcare benefits, including premiums, payment of any retirement benefits, and payment of state or local tax assessed on the compensation of employees. However, payroll costs do not include any compensation to any individual in excess of an annual salary of $100,000, payroll taxes, any compensation to an employee whose principal place of business is outside of the United States, any qualified sick leave or family medical leave for which a credit is allowed under the Family's First Coronavirus Act passed March 18th of 2020. An example of how to calculate the amount that a business would be eligible for would be Harry's Hair Shop applies for a Paycheck Protection Program loan on April 30th of 2020. The business had $600,000 in payroll costs for the period of April 30th, 2019 through April 30th of 2020, which is a monthly average of $50,000 per month. The business is entitled to a payroll protection loan equal to the lesser of $125,000, which is the $50,000 monthly average times the 2.5 factor, or $10 million. So in this case, they would qualify for a payroll protection loan of $125,000. In addition to the Paycheck Protection Loan Program, there is also a provision in here that talks about the loan forgiveness of a portion of that program loan. This separate section of the CARES Act calls for a portion of that loan to be forgiven to the business on a tax-free basis. The amount that can be forgiven is the sum of the following payments made by the borrower during the 8-week period beginning on the date of the loan. payroll costs, which meet the same definition as previously described in the Paycheck Protection Loan Program qualifications, any interest payments on secured debt incurred prior to February 15th of 2020, rent or lease payments in force prior to February 15th of 2020, and utility payments in which service began before February 15th of 2020. To seek the forgiveness, the borrower must submit to the lender an application that includes the following documentation: verification of the number of employees and their pay rates, and canceled checks showing mortgage, rent, and utility payments. There is a provision, however, that reduces the amount that may be forgiven if the employer does either of the following: reduces its workforce during the 8-week period when compared to other periods in 2019 or 2020, or reduces the salary or wages paid to an employee who earned less than $100,000 in annualized salary by more than 25% during the covered period. However, this reduction can be avoided if the employer rehires the employees or increases the employee's pay back up to within the qualifying amount by June 30th of 2020. Using the same example as previously, Harry's Hair Shop received their $125,000 Paycheck Protection Program loan. In the first 8 weeks after receiving the loan, the business paid out $100,000 in payroll costs, mortgage interest, and utility payments. Harry's Hair Shop is eligible to have $100,000 of the $125,000 loan forgiven without creating any taxable income to its business. Additionally, the loan payments on the remaining $25,000 will not be due for another 6 months. Next, we'll move on to the employee retention credit. The CARES Act also includes this 1 year only credit against the employer's 6.2% share of the Social Security payroll tax match for any business that is forced to suspend or close its operations due to a COVID-19 instance, but that continues to pay its employees during the shutdown. Again, on the employer's 6.5% matching Social Security payroll tax expense. Businesses are eligible in one of two ways. First, the operation of the business was fully or partially suspended during any calendar quarter in 2020 due to orders from an appropriate government authority resulting from COVID-19. Or the business chose to remain open, but during any quarter of 2020, the gross receipts for that quarter were less than 50% of what they were for the same quarter in 2019. The business would then be entitled to a credit for each of those quarters until the business has a quarter where it has recovered sufficiently and that its receipts exceeded 80% of what they were for the same quarter in the previous year. For each eligible quarter, the business will receive a refundable credit against its 6.2% share of the Social Security payroll tax match, equal to 50% of the qualified wages paid to each employee for that quarter. Wages paid during the time period of March 13th, 2020 and 12/31 of 2020 are eligible. Qualified wages in this scenario depend on the size of the business using their 2019 employee count. Qualified wages for businesses with more than 100 employees during 2019 consist of wages paid by the employer during the period of time the business was shut down and are limited to 30 days per employee. However, qualified wages for businesses with 100 employees or less during the 2019 period are wages paid by the employer during the period of time the business was shut down, plus wages paid for each quarter in which the business suffered a sharp decline in year-over-year receipts. Alternative methods would apply for tax-exempt organizations to use. In both cases, the qualified wages include qualified health plan expenses allocable to wages, such as amounts paid to maintain a group health plan. In either case, the amount of the qualified wages for each employee for all quarters may not exceed $10,000. There are some restrictions on the employee retention credit, however. Wages taken into account in determining the new payroll tax credit for any family, medical leave, or sick leave as part of the Family First Coronavirus Response Act passed on March 18th of 2020 will not be taken into account in determining qualified wages for this credit. Also, if an employer takes out a loan utilizing the Payroll Protection Program established through the CARES Act, which we previously went through, no employee retention credit will be available. Additionally, employers cannot use the employee retention credit for wages in which they have already received credits under the Work Opportunity Tax Credit or Paid Family Medical Leave Credit. Next, we'll discuss the delayed payment of employer payroll tax and self-employment tax. In an effort to alleviate the burden on employers struggling to make payroll, the CARES Act would allow the employer's share of the 6.2% Social Security tax to be delayed. The employer's 6.2% match of the Social Security tax is calculated from the date that the CARES Act was enacted through 12/31 of 2020, and those amounts would be eligible for the delayed payment. Payment of the delayed amount would be paid in 2 equal installments due by the end of the year in 2021 and the second installment by the end of the year in 2022. Self-employed taxpayers can defer paying 50% of the self-employment tax attributed to Social Security tax, again the 6.2%, that would be due from the date of the enactment through the end of the year 2020, with payments made in 2 equal installments, again due at the end of 2021 and 2022. Therefore, an employer may not only defer the payment of their 6.2% Social Security match until 2021 and 2022, but they may also receive an immediate credit against those deferred payroll taxes should they qualify for any of the payroll tax credits established by the Families First Coronavirus Response Act or the CARES Act. However, the deferral is not available to any business that takes advantage of the loan forgiveness provision of the Paycheck Protection Loan Program. And finally, we'll discuss an overview of some of the unemployment insurance provisions. The CARES Act creates many new provisions related to unemployment insurance and coverage, including the Pandemic Unemployment Assistance Program, the Emergency Unemployment Relief for Government Entities and Nonprofits, emergency increase in unemployment compensation benefits, temporary full federal funding with no waiting week, and the financing of short-term compensation payments within the states. First, the Pandemic Unemployment Assistance Program. This provides payments through the end of 2020 to those not traditionally eligible for unemployment benefits, including the self-employed, independent contractors, and those with limited work histories that may be applying for unemployment. The Emergency Unemployment Relief for Government Entities and Nonprofit Organizations provides payments to states to help reimburse nonprofits, government agencies, and tribal entities for half of the costs they incur through the end of 2020 to pay out unemployment benefits. The Emergency Increase in Unemployment Compensation Benefits provides an additional $600 per week payment to each recipient of unemployment insurance or pandemic unemployment assistance for up to 4 months. An additional section to the bill was added to include an additional $600 per week payment to each recipient of railroad unemployment insurance benefits for up to 4 months as well. The temporary full federal funding of the first week of compensable regular unemployment for states with no waiting week provides funding to pay the cost of the first week of unemployment benefits through December 31st, 2020 for those states who choose to pay recipients as soon as they become unemployed instead of waiting 1 week before eligibility. An additional section was added also to eliminate the first week for railroad unemployment insurance benefits as well. The Pandemic Emergency Unemployment Compensation provision provides an additional 13 weeks of unemployment benefits through the end of 2020 to help those who remain unemployed after weeks of state unemployment benefits have been exhausted and are no longer available. Additionally, these additional 13 weeks of unemployment have also been extended to the railroad unemployment benefit recipients as well. We'd love to help Please feel free to reach out to myself or any one of our experts at Brady Martz for additional assistance, and keep checking out our website at www.bradymartz.com for more updates and more specific information regarding these new provisions. Thank you and have a great day.